David Kempston is an attorney with Motez and CISC injury law. He frequently lectures on the Minnesota Workers' Compensation Statute and is a co-contributing author to a chapter in the Minnesota Workers' Compensation Desk Book and has written 2 books. As you may know, change was afoot in the field of vocational rehabilitation before COVID-19. However, now the virus has accelerated the process. Some say rehabilitation is a dying profession, but QRCs perform an essential function for injured workers. Dave will share an attorney's perspective on how to do vocational rehab the right way. You'll find him to be both challenging and entertaining. Please welcome Dave Kempston.
Thank you very much. Glad to be here this afternoon, or stated otherwise, glad to be sitting in my office talking at a screen here with you this afternoon. My name's Dave. I've been a work comp lawyer for almost 28 years. Who's counting? Long enough to have 4 kids and 4 grandchildren. So you may call me Grandpa Dave if you would so like. That would be just fine. My topic today is best practice, or what should I do? You're probably thinking, what on earth can a plaintiff lawyer tell me about voc rehab? That's fine. I brought a prop for you. I'm sorry that I can't disperse this as we sit here today, but feel free to take an imaginary swig of my Pepto-Bismol if that helps you get through the remainder of my presentation today. So the answer to the question, what should I do during this challenging season, is, pretty much you want to do the same thing as doctors, lawyers, plumbers, cooks, watch repair people, those sorts of things. You want to work cheerfully, diligently, and honestly. All right, thanks for your time. No, I'm just kidding. Actually, we do want to do those things, but it can be challenging to do those. And back to my question a little bit earlier, I said, what on earth could a plaintiff lawyer know about how QRC should function? The honest answer to that is much more than I used to know, much less than I could know. My own exposure to vocational rehabilitation came about 28 years ago when I was a bright-eyed, aggressive, that's capital A, and clueless young insurance defense attorney at a downtown insurance defense firm. And at the last minute, a partner asked me to cover a rehabilitation conference. And I didn't even know what rehab was. I thought it was physical therapy. And so I went to this conference, and it had to do with payment of QRC bills. And I didn't even know what a QRC did, let alone how they did it. But don't confuse me with the facts. I'd already made up my mind, and it was clear to me that whatever was done wasn't necessary. So that was about 28 years ago. Since then, much has changed. A few years after that, I went to work with Tom Motez and spent the last 24 plus years on the plaintiff side. Have worked with hundreds of QRCs, have tried hundreds of cases, have taken lots of QRCs through direct, have cross-examined lots of QRCs, have read innumerable QRC reports. And I'm going to tell you right now that QRCs serve a terribly important function. One that the 24-year-old Dave Kempston did not understand. I will often tell my clients now that a good QRC is worth their weight in gold, and that conversely, a bad QRC is like having a pair of cement shoes on your file. And I mean that. A good QRC is essential. I think of a 3-legged stool in the work comp system. I think of, maybe the doctor is a leg, the QRC is a leg, maybe the attorney is a leg, and then the employee is the seat of the stool. It's not a perfect analogy, but all analogies break down if you push them too hard. But oftentimes when potential clients come to me and say, gee, Dave, I'm just checking out my rights. Do I need a lawyer? Do I not? I will often tell them, after explaining their rights, they don't need a lawyer, but they do need a good QRC. So as I prepared for this, I've talked to a number of different QRCs and received some inquiries, and I've talked to some QRCs who have retired or who are long in the tooth. I won't tell you if they're older or younger than me. We'll just say they're long in the tooth. That's adequate for our purposes today. And I've heard a recurring theme that is troublesome to me, and that theme is this. David, I have some regrets about the career path that I chose. David, my profession is a dying breed. David, they've taken the vocational out of vocational rehabilitation. So, those are the sorts of thoughts that have been communicated to me by people who are either presently in the industry or previously were in the industry. And each time I hear that, I push back with, no, you serve a terribly important function. And part of that was taught to me when I was a young attorney. I came to work with Motez. It was pretty humorous because I was starting to get a book of business, and I reached out to a QRC who'd done a number of vocational evaluations for me. And I said to this QRC, hey, it looks like my volume is starting to turn up, and I'd like to develop a relationship with some QRCs that I would feel comfortable working with. And I'd love it if you would be one of them. And this QRC told me, David, I'm sorry, I'm not in a position to do that. It would upset my other sources of referrals. And I said, okay. It was interesting because over the years, I've represented hundreds and hundreds of injured workers and made referrals many a times to QRCs on those files. So my first swing and a miss, I knew I needed a QRC who could teach me, since I had learned at that administrative conference earlier that I didn't know anything about voc rehab. And fortunately, there were two QRCs who took me under their wing, and they taught me a lot. And one of them taught me that, David, you've always got to understand what the goal of statutory rehabilitation is. I think another way of saying that is, if you don't know where you're going, any train will get you there. So if someone says, what is your job description? Well, you look at the statute, 176.102. You look at the part that defines, what the goal is: to return an employee to an economic status they would have had or enjoyed but for the disability. The goal is to get them to suitable gainful employment. Those phrases are synonymous. And it's so important to understand that. And, if you're going to do it the right way, if you're going to practice the best way, what the goal of statutory rehab is. And the reason you want to know what the goal is because then you're going to avoid the pitfalls of what I call good enough rehab, which is, hey, they got a job and it's good enough. So first thing is understand the goal of statutory rehab. The second thing is understand the polarity. The polarity that lies within the field. I referenced this earlier when I talked about reaching out to this QRC who said, no thanks, but no thanks, Dave. Where am I going with that? There is tremendous polarity within the field of voc rehab. If you think about it, you think about a battery, all right? And we've got a positive and a negative, and that's kind of how it is in the comp system. And you've got this pull. You've got the insurer, employer, and the injured worker. And I'm not saying one's positive and one's negative. Both have rights. My favorite line from White Christmas, right? Mutual, I'm sure. The work comp statute puts mutual obligations, creates mutual rights and responsibilities. It's not just for the injured worker. It's also for the employer, and it's also for the work comp insurer, so they know what they're writing, what risk they're underwriting. But within that field, there's a lot of polarity. And there tends to be a leaning toward, say, the injured worker or toward the employer insurer. It just naturally, it's how some of us are wired. Other times it's where the bread gets buttered. Let's be honest. If you've got a referral source, maybe you're going to give them the benefit of the doubt. But when push comes to shove, you're going to see where that needle goes when the wind starts to blow real hard. That said, so we acknowledge there is polarity within the field. There just is. That said, another QRC taught me that good QRCs maintain the appearance of neutrality no matter which way they lean. So it's fine to have a predisposition inside, but as you do your job, you want to maintain the appearance of neutrality. And I'm not talking about deceit. I'm talking about being a neutral, maintaining that appearance. You're going to service the parties better that way. I've already told you that a good QRC is worth their weight in gold. And a bad QRC, in my opinion, is like a pair of cement shoes. And what I mean and don't mean by that is I don't mean that the good QRC is the insurer's gopher who does what they're told to do. All right? No, I don't mean that the good QRC is just an arm or an extension of the lawyer and says whatever it is they're supposed to say. No, not at all. The QRC's job is to, do two things, I tell my clients. One is to do medical management. That is to assist oftentimes an unsophisticated consumer of medical services navigate through a complicated medical system. And things that are second nature to QRCs are not second nature to most injured workers. Similarly, communicating, interfacing with the insurer, a lot of times a QRC can really be helpful that way. I realize I tell my clients, hey, a QRC doesn't swing a bat. And what I mean by that, if something is denied, the QRC doesn't have the ability to go and get it for the injured worker. But boy, they do a good job as that liaison. So part one, they do medical management, this important function that they perform. The second important function they perform is the vocational piece. That's the return to work. So I tell my clients, hey, a QRC wears two hats, all right, the medical management hat and the return to work, or what we call the voc rehab hat, because I am going to keep the word vocational in the phrase vocational rehabilitation because that's where it belongs. What I have found over time is that some QRCs are good at one, but not the other. Some QRCs really don't care. They just view themselves more as disability case managers. And I'm not dissing disability case managers. That has a function, whether it's, I'm in the work comp system, I'm not a disability case manager fan. As a matter of fact, if statutory rehab is appropriate, I'm always going to push for that. But in other venues, disability case managers are appropriate. But some QRCs will approach voc rehab from a disability case management standpoint, and they need to go back and think about what is the goal of statutory rehab. Now, I talked about the polarity that is within the field of voc rehab, and that's a hard thing. I mean, it's a hard thing, and QRCs are in the middle. I'm not telling you, I presume I'm speaking mostly to QRCs. I'm not telling you anything you don't know. You're like, yeah, Dave, I am in the middle. And people in the middle tend to get squished. You do, whether it's the abusive attorney, the cranky client, or the intrusive insurer, who are all pushing and clawing and pulling and trying to get something out of you. So you have a very hard job, and I understand that. And as I speak today, I'm not so much going to get at the substance of how you do what you do, because I'm not a QRC. And I have read the rehab rules a couple of times. It does not make me an expert on the rehab rules. I'm going to leave that area alone. What I'm really going to focus in on is process, how you do what you do. And, I didn't even show you how silly this I was as a youngster. I was an English major in college and went to law school at the University of Minnesota. Started there in the fall of '89. Yes, they had cars back then, but not many people had computers. As a matter of fact, after listening to the end of John's presentation about AI, I chuckle because when I went to law school, only one of my classmates of 225 lawyers had a desktop. And I think it cost like over $5,000, and he was wealthier than the rest of us. And that's why he had a desktop. So the whole point was that things changed. But when I went to law school, I didn't know anything about the differentiation between process and substance. And in fact, if you had said to me, David, please explain the difference between substance and process, or substantive law and procedural law, I would have had no clue. And so you go to law school and they immerse you in this world. I often tell people it was like having my head shoved in a cold toilet bowl. It was just kind of shocking. It was just a whole new world I did not know existed. And so we spend all this time learning about process, and process is very important. We talk about due process, we talk about procedure, we talk about equal access to justice, we talk about fairness. Those are the concepts that get imbued into how we do what we do. So, as a lawyer, it's so important to think through how I do what I do. As a QRC, it is no less important to think through how you do what you do. And it's a great time, COVID notwithstanding, it's a great time to do the right thing the right way. Now, I'm speaking in platitudes and vaguely and ambiguously because, remember, Pepto-Bismol time, I'm a lawyer. But it is good sometimes to step back and think about how we do what we do. So I like to run. When I was younger, I would introduce myself at seminars and say, I'm a self-avowed philologist, a lover of books, words, and learning. Okay, but I've lost that one. And now I'm just an admitted inveterate runner. Okay, that's really what I like to do. I mean, I like to read books and I like to run and I like to hang out with my grandkids. So with COVID, before COVID, I used to run out of a health club and I'd run out of Lifetime, and there are Lifetimes all over the Twin Cities. So I could hit a Lifetime on the way to court. I could hit one on the way to work. I could either hit the Champlain Club or I could hit the Grand Rapids Club and then do my workout and get dressed, take a shower, that sort of thing, work out, come to work. Obviously, COVID closed the club, so I've been running from home. And I have been running the same route for a while now. I'll make it longer, shorter, run faster, run slower, whatever my achy grandpa body feels like on that particular morning. But I began to notice as I ran, because I usually run on Tuesdays, Thursday mornings during the work week, and then on the weekends, I would go by this fella just about every time at a certain spot in about a half-mile window. I'd run by him and hi, whatever. And I keep thinking, I know this guy. So finally, after I do that for about a month, this was about a month ago, I stop and I say, hey, I know you. And he's like, what do you want? Pulls out his mace. No, he didn't. Turns out his name is Walter, and he's a fella that I used to see at the Eden Prairie Lifetime pretty regularly. That's why I recognized him. And but I didn't get his hat on, and he's shuffling along with his newspaper clutched in his hand. So we started talking, and we talked about, are you going to go back to the club? And we're taking a hiatus, me and my wife. And Walter started to talk to me. He says, I think I'm going to head back to the club because it's getting too dark to walk. It's not safe. He said, but that said, he says, this hiatus from the health club has helped me save some money. He says, I've dropped weight. And he says, my blood pressure is the lowest it's been in years. And I thought, well, that's interesting. Here we are in a season of distress and duress, otherwise known as the COVID pandemic. And Walter is telling me about things that have been of benefit to him. And, I thought about that. But for that force of, so I say bye and I run home and I tell my wife all excitedly about talking to Walter. And she's like, you shouldn't accost strangers while you're out for your morning run. And I was really struck by this, probably more than I should have been. But, this pause in Walter's life is caused by the pandemic. And, you think of pauses in life. In music, there's a caesura. I'm not a musician, but it's a moment of silence, and it's planned. I used to work with high school kids, youth group in particular. And we oftentimes have small group sessions, and there would be lots of pauses, and I would always call it the pregnant pause. And I'd tell the kids, hey, you don't got to rush in and fill that pregnant pause with something. You can just be quiet and think. So we have this pandemic upon us. And it's one of those teachable moments. There was that saying a bunch of years ago about never let a good crisis go to waste. And it had to do with ramming legislation through. But it is moments of crises that cause us to think through how we do what we do. And it's really important, back to where I was about 10 minutes ago before I bored you to death with Walter stories, it's really important to think through how we do what we do, because they say, one of the definitions of insanity is doing the same thing over and over and expecting the same result. Now, I'm a person who's a firm advocate in systems. I am systematic. For example, if I take on representation of an injured worker, I plan to try that case. That doesn't mean I'm going to. I settle way more cases than I try, but I've tried hundreds of cases in the last 28 years. So I have a system in place, and the way I gather the medical records, the way I put the case together, I just assume I'm going to try it. And if my system is in place, I'm doing the same thing on each case, and I don't have to wonder if I did it that way. Now, that said, I can't be a cookie cutter. Why not, Dave? Well, because each case is different. How many of you have children, all right? How many of you have more than one kid? How many of you have more than two kids? Sure. I have 4 children. I have 4 grandkids now, and they are all different. It's remarkable how different they all are. And clients are similar. It reminds me of something that Motez once told me. He said, David, We didn't give birth to our clients. We just represent them. So that's true. Good thing to keep in mind from time to time. That said, back to this idea of the difference with the clients that you're going to be working with. You want to have a system in place for how you deliver vocational rehabilitation, but it can't be a cookie cutter approach. And so, again, swerving away from the substantive area of what is required of you under the rules and focusing on the process of how you deliver those services is where I'm going to go. And when I emphasize process, I'm not saying don't know the substantive area of voc rehab. You should. You should know the rules. You should know the requirements and the rest of the rules and procedure, but you should have a good knowledge of the substantive area of voc rehab. But you should also seek to excel at how you provide the services, how you do what you do. You know, to focus on one of these, losing the other is a false dichotomy. It's like saying, gee, Dave can't wear a yellow tie because he's got a blue shirt on. You might say, gee, Dave, I wouldn't wear a yellow tie because you have a blue shirt on, but that's a different issue. So I don't want to set up a false dichotomy here, but I want to go down a particular lane with you. So how to deliver vocational services. And I haven't thought about that a ton for QRCs. I've thought about it a ton for lawyers. I mean, I thought about it so much, in fact, that I wrote a book about it. There's got to be a shameless self-promotional plug. But how we interact with clients is terribly important. So some things that I want you to think about, whether you use today as a pause or this season has been a pause where things are changing, business slows down, it's just not quite the same. It's a great time to take inventory and think through how you're doing, what you're doing, and avoiding the insanity of just doing the same thing more and more and more. And, you know, my grandpa used to say that if it was supposed to be fun, they wouldn't call it work, Dave. And then, okay, I guess so. And there is a lot of toil in work. There's a lot of grinding out that must be done. And I understand that, but there is also joy in work. I believe that we were created to work, and I believe that, you know, there's satisfaction and joy in a job well done, in being fruitful, in providing valuable services. So now some things that a QRC can do or think about doing as they approach their practice. First is to understand that the relationship isn't about you, all right? I realize you're the professional, you're registered with the state of Minnesota to provide vocational services to the injured worker, you have licensure, you have a good education. You're important. You are. But the relationship isn't about you. It's not about serving you. And I understand this is how you make a living. I get that. And you say, gee, Dave, that's pretty humorous coming from a lawyer. I know. I've preached this at my own ilk on many an occasion. And I think understanding, you know, the relationship isn't about you. I mean, you're an important part of it. You're one of those legs of the stool that I talked about earlier. But you're there to provide vocational rehabilitation services to the injured worker. And once that goal has been accomplished, then since the relationship isn't about you, you close your file. You know, years ago, I had a QRC who is now retired, who would not give a perm total opinion on a case where the fellow had been off of work for, 3 or 4 years. He'd been awarded SSDI. And I kept getting excuse after excuse after excuse about why, you know, the file needed to remain open. And it just didn't make a whole lot of sense to me. And I learned a little bit later that this particular QRC had set it up so that, you know, weekend trips coincided with clients who were located up north. And there were just some stuff that was like, really? Now, again, I'm not here to throw rocks at QRCs. That's not my point. The one who lives in a glass house should not throw rocks, right? Lawyers are the worst. We're worser than QRCs at this one. But I think it's a great place to think about how to do it the right way, is to understand the relationship is not about you. A second important factor in providing good voc rehab is to set realistic expectations. And I don't know if you do this during the initial consult with the client, but sure makes sense. You know, I will often, when I explain what a QRC does, I will often tell my client, and in order for you to understand this, I'm going to tell you what a QRC is not. QRC is not a lawyer. QRC is not a claim rep. QRC is not a doctor. QRC is not a physical therapist. QRC is not the agent of the employer. QRC is not the agent of the insurer. You get the idea. Sometimes it's easier to define something by telling you what it is not. And so if you have a client, an employee who wants you to run interference in an inappropriate way, and you explain that's not my job. You explain that kindly, but you explain that it's not your job. Similarly, when you have an insurer who wants you to set up an independent medical exam, not your job. Or you have an insurer who's pushing you, hey, see if you can get, Billy Bob released without restrictions at the next doctor visit. I always tell clients, hey, look, doctors write restrictions. Insurers don't, QRCs don't, lawyers don't. Okay. So setting realistic expectations. Now, that can be a hard conversation. And frankly, I had an old friend who used to say, David, boundaries are easy to establish, but difficult to enforce. So sometimes you have to remind people of what your function is. And I think it's important to do that because people get frustrated when they have expectations that aren't met. Third one, for providing good voc rehab, doing it the right way, is to be a good listener. And I find that QRCs are better listeners, I think, than lawyers by and large. I say that because I've read many reports from QRCs, and I've called the QRC and say, whoa, I didn't know that. How'd you find that out? Well, I just listened, Dave. I asked and I listened. Something I need to do a better job of. So being a good listener, listening to the insurer talk, listening to the lawyer talk. I'm not saying you don't talk, but hearing people, hearing what it is that's being expressed. Another really important point is to trust your gut. Now, we like to think of intuition as something that we're born with or we're just wise. I don't think so. I think intuition is something that is formulated by working in the trenches, by having life experience. And trusting your gut. When your alarm goes off and you're thinking something ain't quite right here, I'm not saying that you need to go and tell on somebody or report. That's not where I'm going with this. But I'm saying for you, especially since you're in the middle, you want that radar working well. And if you're having second doubts about something somewhere, document. You don't have to document a report, but document it somewhere. So to trust your gut. It's terribly important in this business. Fifth one, it's really important to provide good voc rehab, is to be kind. And I was reminded of this today. I just was on the phone with a client 2 hours ago, and I told this client the truth, but frankly, I didn't tell the client the truth in a very kind fashion. I got impatient. And I do that, and that's a failing of mine. So be better than me, all right? Be kind. You can be as firm as you want and as gentle as you want. Just picture a brick in a velvet glove. Now, when I say be kind, I'm not saying that you're a yes person, that you need to just agree with everything everybody says. No, you don't. I mean, being kind doesn't mean that you enable somebody. It just means that in your interactions with other people that you are pleasant, that you are professional, that you are courteous. Even when you get the snide emails. Anybody get snide emails? Good grief. Oof, I get lots of snide emails. When you get those emails, pause, choose, reflect, choose to respond just kindly. And the sixth one that's really important is to be truthful. And I'm gonna dive into this one a little bit. I know that it's rather humorous to have a plaintiff lawyer telling you to be truthful, but I always tell my clients, tell the truth. It's the right thing to do. It's the easiest thing to do. And by golly, they're going to find out anyway. We're in an adversarial system. And the idea behind the adversarial system is that you have two opposing attorneys or two opposing forces going at each other. And what that does is that they emphasize the strength of their case and they point out the weakness of the other side's case. And judges, fact finders like that because it makes it easier for them when they're sifting through the evidence, because you've got two adversaries who are pointing out the relative strengths and weaknesses of the respective positions. So you're in an adversarial system. There's truth there. Now I also understand that we see things through a dark glass dimly. Okay, what do I mean by that? So I'm a Vikings fan. Yes, it's a rough start. And if you're a Green Bay Packer fan and you watch that first game of the season, you might have had your Packer glasses on. I might have had my Viking glasses on. We may have been watching the same TV and had it taken away a different experience. So I understand that our perspective is going to dictate some of what we see, but to the extent it's up to you, be truthful. So say, David, you've just been speaking in generalities. You're not really helping me. David, I haven't needed your Pepto-Bismol yet. All right, here we go. So how can a QRC be truthful? Close the file when it should be closed. All right, don't keep it open like that file of yesteryear. Think about the old days with placement. There was the phrase that was kind of going around that, don't kill the golden goose, or did somebody kill the golden goose? I had a couple of files 10, 12 years ago where the bills per month in placement were flabbergasting. Honestly, it's my favorite F word, polysyllabic F word. I was flummoxed. There you go. Wrote down another one for you, 2 F words in a row. And I'm not saying that people weren't being truthful, but yeesh, there were some spooky circumstances that I saw in a couple of files. Being truthful involves not overbilling. Okay, do you take the same material and transmit it 3 different ways and bill for it 3 different times? Careful, it's probably not appropriate. A big one from my perspective, is a lot of times when I'll talk to a QRC that I haven't worked with before, I will say, as we work together, here's what I expect from you. I expect that, if I ask you, you're going to tell me what you plan to do. And I realize you don't have a crystal ball. I don't expect you to predict the future. But, if you chart out a course of action, I expect you to adhere to what you told me you were going to do. And then if you change your mind or something comes up and you're going to go a different route, I expect you to call me up or email me and say, Kempston, something came up. I was going to go left at the street up here, but now I got to go right. Here's why. I don't have a problem with that. Things change. I get that. Things change. This isn't cookie cutter rehab. But that said, having somebody say one thing and then do another is rough. And in this context, I think it's important to understand, even though you are in the middle, you can take a position. And it doesn't mean that you can't later change your mind when presented with new or additional information, but it's okay to take a position. My experience sometimes with QRCs is that they want to please everybody. They don't want to make somebody upset. I had the funniest conversation a bunch of years ago before I was going to try a case. And I called this QRC and said, this was a couple of weeks before the hearing, I was trying to get a handle on things and called the QRC and said, here's what's going on. The hearing's coming up here. What are you going to say? What can you say? QRC says, I'll say X, Y, Z. So I emailed the other lawyer. Hey, I talked to QRC. QRC says he's going to say X, Y, Z. Other lawyer, David says, well, I talked to QRC, and the QRC says he's going to say ABC. Or not X, not Y, not Z. I'm like, what we have here is a failure to communicate, to quote Eddie Murphy. So from a long time ago. So I go back to the QRC and I call the QRC. What's up? Well, and really, as I pushed the QRC made it clear that they were uncomfortable in the middle, that they didn't care for lawyers. They didn't want to be stuck in the middle. They didn't want to be an expert witness. And I get that. But that said, that is one of the elements of the job. And I think it would have been better in that case, instead of that QRC trying to please everybody, because there were just multiple phone calls back and forth, trying to figure out what what's going to be said. By the time we were done, neither myself nor the other attorney had any idea what the QRC would say under oath, and ultimately we settled it. So maybe that QRC was intelligent enough to know that if both sides were played against each other, it would allow for an exit. I don't know. But be truthful. Another very important thing to do as a QRC is to act like you care. Better yet, care. So, like I said, admitting failings here, I didn't act like I cared about 2 or 3 hours ago on a phone call. And, it's important in our business. We are toxic handlers. Think of all the waste that gets dumped on you, QRC in the middle. You hear it from the injured worker because you are the face for the system. So you are the punching bag sometimes, or the insurer who takes out their wrath upon you. It's your fault that the employee is a slug. It's your fault that the doctor has vehemently kept the injured worker off of work, even though there's light duty available. The attorney's furious with you because the employee isn't making a diligent job search. That's your fault, right? Yeah, here we go. It's not your fault. So you are a toxic handler. You're just getting all of this toxic waste dumped on you frequently, not all the time, but frequently. And it can be hard to act like you care. But I think it's important. It goes back to that maintaining that appearance of neutrality. Acting like you care is an element. One way to act like you care is to be timely. Be timely in your responses. And no, I'm not Mike Hill, so I don't chase you down if you file a progress report late or something like that. Sorry, Mike. But, if an inquiry is made, you should respond in timely fashion. And a great rule is the 24-hour rule, just to let people know you'll hear back from you within 24 hours and do that. It's one thing to say it, it's quite another to do it. And you can do it. I always tell my clients, look, you'll hear back from me in 24 hours of an inquiry, unless I'm dead, something bad happened, or I'm out of town. I've had bad things happen. I've been out of town a lot. And people hear from me within 24 hours. Sometimes it's just calling back, emailing, saying, hey, I'm out of town. I can't look at this till next week or whatever. But that way, you're not AWOL. And so timely responses are really important in presenting a demeanor that says, I care. I care. All right. Another really important thing that QRCs can do is keep it simple. Keep it simple. I'm going to dive into this one a teeny little bit as regards reports. There are differing theories on reports. Sometimes I read an initial report and it reads like a doctoral dissertation. I learn, what this person's third grade report card said. I learn, that they delivered newspapers in junior high at $3.50 an hour for 6 months. And even if it's a perm total kind of a claim, I'm not sure that's terribly relevant. So, and I understand, people are taught differently and different firms have different requirements. And if you work for a national firm, you may have some corporate requirements that you have to satisfy. But, the longer the report, the harder it is for people to read. I get a lot of QRC reports and I read them. It's important to read them. A lot of times the QRC report is sometimes the first notice I have of what's going on. It's usually the first time I hear about what the doctor had to say. It's usually by far more accurate. So short reports that get at vocationally relevant issues, that get at doctor visits, restrictions. There's a QRC I used to know who retired a long time ago that wrote short reports. And I asked this QRC about that once, and this QRC said, Kempston, you can't get hung with the words you don't say. And there's truth to that. And I'm not saying you omit important things. That's not where I'm going with this. But think of that great line. If I'd had more time, I would have written you a shorter letter. There's the idea. Another really important thing in providing good voc services is don't procrastinate. Start right now. Do it. Just get her done. There you go. Closely affiliated with that is this idea of doing the work. Doing the work. Right? There is work to be done, and I know I have received some emails and some inquiries from people saying, David, work is down. And it's not unique unto voc rehab. And chatting with other plaintiff lawyers, I hear that. In chatting with, the department, claims are down. So perhaps there is less work to do for you. And I'm not addressing that right now. But relative to the work, do the work. It's important to do the work. There is no substitute for doing the work. Ernest Hemingway had a wonderful saying one time. He said, work, that's the main thing, no matter what happened the day or night before, get up and bite on the nail. So work needs to be done. But don't overwork. Don't overwork the file. If you're doing placement, do you send out a weekly report or do you send out a monthly report? A monthly report might suffice. Again, we're back to this. Are you sending out multiple messages that all contain the same info and billing for it? I don't know that you need to do that. I'll leave that up to you. So do the work, but don't overwork. Next one that's really important is to be prepared. And I want to dive into this one a little bit. Mike Hill had asked me to talk about depositions and had indicated that there are a number of QRCs who don't like to be deposed or don't like to testify. And I certainly understand that. So I'm putting deposition instructions or hearing testimony, tucking it under this be prepared category. The good book says that love covers over a multitude of sins, and a corollary for that is that being prepared covers over a multitude of sins. So, my motto is be prepared, be prepared, be prepared. That way, if you are testifying or giving a deposition, you know your file. You know it inside and out, okay? But before you dive into getting prepared, you need to know what you're getting prepared for. Again, if you don't know where you're going, any train is going to get you there. And so if the other lawyer, someone sets your deposition, it is okay to reach out and say, hey, you set my deposition. I'm just curious, what's this about? I mean, the worst you're going to get is a cranky email that says something that I shouldn't say out loud, but probably that's not going to happen. The lawyer, we don't think she's doing a good job. We don't think he's doing a good job. Or whatever. Okay. So you can reach out to the, if it's defense counsel, you can reach out to the plaintiff lawyer. Hey, I've been set for a deposition in Susie Q's case. How come? What's up? So feel free to reach out and find out what the issues are. Because when you get prepared, you want to know what it is that you are preparing for. And then you're prepared, you review your file. It's a good idea to bring your whole file with you. All right. And the other lawyer has the right to go through the file. That can be shocking to some people, but they do have the right to look through your case notes. I had a funny experience about a year ago. QRC was testifying at a hearing, and that QRC brought that QRC's bag up to the witness stand. This was pre-COVID when we could actually appear live in the courtroom. And QRC sets the bag down. I took the QRC through direct. The opposing counsel is cross-examining the QRC, but before that starts, the other opposing counsel dives into this QRC's bag and starts rummaging around. No warning, just goes into the bag, starts looking around. And I was concerned that, there was going to be some sort of, dirty workout clothes or something unseemly in the bag, but there wasn't. the judge was very upset. I didn't have to say anything. It was hilarious. I just sat back and I didn't say anything. The QRC was like, "What are you doing?" And the judge was like, "Yes, what are you doing?" To opposing counsel. Opposing counsel was, "Well, this QRC brought this bag to the stand. I have the right to go through it." And the judge, and at that point I said, "Based on what legal principle?" I mean, it's one thing if there's a file there, but to just rifle through someone's bag. So anyway, my whole point is that yes, depositions or hearing testimony can be very invasive, but they shouldn't just start scrounging through your bag. That's inappropriate. And the judge did shut it down rather quickly that day, which was, again, pretty humorous. I've tried a lot of cases. I've never seen that before. Sorry. So you know the issues, you know your file, and then take a position. I talked about this earlier, that it's okay to have an opinion about something. And I know that may make you unpopular with one side or the other. And you say, "David, that's hard. I want to be liked. I'm supposed to maintain the appearance of neutrality." Yes, you are, but it's okay to take a position, to have an opinion. You're an expert. You're a vocational expert. And I know lawyers talk down to you sometimes. Insurers talk down to you sometimes. Your client talks down to you. I don't care. You're the vocational expert. I'm not. Maybe what I do with QRCs before I'm going to take them through either a deposition, or if I was going to defend their deposition, or if I was going to take them through testimony at a hearing, I'm going to meet with them. In the old days, it would be in person or by phone. These are documents you should look at. These are the questions I'm going to ask you. And I don't go over absolutely everything because, again, it's not cookie cutter. You want to be prepared. But by being prepared, you can then be flexible when you get there. So this idea of being prepared, reaching out, educating yourself. If a plaintiff lawyer has asked you to testify at a hearing, reach out to that plaintiff lawyer and say, "Hey, what do you want me to, where are we going with this? I need to know." It's not what do you want me to say. It's what are you going to be asking me about? A lot of times I'll say to the QRC, "Hey, this is what I'd love to hear you say." And if you can say that, great. And sometimes the QRC will say, "I can't say that, Dave." I'm like, okay. And then, I might ask, "Well, why can't you say that?" And they'll go, "Well, this was one time I had a QRC saying the person wasn't making a good faith effort to cooperate with rehab. And then so I said, "Okay, so tell me why not." "Well, I doesn't always keep in touch." Okay, well, I had some friends that went to med school and they used to tell me, "Kempston, C equals MD." I'm like, "What? C equals MD? What's that mean?" "All I got to do is get C's. I'm going to get my medical." I said, "Wow, I don't want you to be my doctor." My point here is an employee doesn't have to be perfect. All right, so what are the elements of good faith effort to cooperate with rehab? Are they keeping in touch with the QRC? If placement's going on, are they keeping in touch with the placement person? Are they submitting job logs? Are they following up on leads? Are they following up with their medical provider? Are they keeping the parties informed? Are they, whatever does the JPPA require? Is there a JPPA on the file? What does it require? Those sorts of things. So I queried this QRC, and as we went through some things, QRC kind of, "Well, yeah, I guess if you look at it that way, you could say that he's doing a good faith effort." And, other times I'll have a, the defense lawyer get all excited. "Well, they're not doing a job search. It's not diligent." Well, there's no job search required under the rehab plan. What's the rehab plan? What are the requirements that are in place for this injured worker? And if job search isn't one of them, me as a plaintiff lawyer doesn't care when the defense lawyer gets all excited that they're not doing a job search. Yeah, they're not supposed to. I don't like that. Amend the rehab plan. So again, this idea of knowing what the issues are, leaning on counsel a little bit to help you, whether it's the defense lawyer or the plaintiff lawyer, doesn't matter. Reach out, ask, but then take a position. And again, that position can be amenable to change if you're given new information you didn't know, but have an opinion and a basis for it. And if a lawyer shows you something, says, "Hey, is this your work?" You say, "Yep, I wrote that book." That's okay to admit. If it's an email, "Is this your work?" Yes. That's just asking if you authored it. Don't answer questions off of documents that you haven't looked at. Make sure to look at something before you say, "Yes, this is mine." Just look at it quickly. Too many times we'll say yes to something and it turns out it's only half of it's there. It's missing the latter part, or two pages got stapled together improperly. So I kind of dove into this one, but being prepared, especially in the context of giving testimony, is appropriate. And if the questions are inappropriate, if the lawyer is trying to yes, no you, you don't want to get argumentative. But the flip side is, if you can't answer the question, or if you don't understand the question, you ask for the question to be repeated or rephrased. And if they're misstating evidence, especially what you just said, that's a classic lawyer trick. You're testifying for 10 minutes and then the lawyer goes, well, let's recap what you've said thus far. X, Y, Z. And you're like, no, I didn't say X. I did say Y, but I didn't say Z. So you don't have to agree to things that aren't true. So I'm going to leave that one alone. You get the idea. Best practice is to be prepared. And that's really going to pay off in the context of having to give testimony. Next thing that's going to help you be a better QRC or deliver services more effectively is to communicate clearly. Talked about this a little bit with short reports. Emails that don't use flowery language. Use short words. They work best. Eschew words like, flummoxed or things like that. Go with, I was confused. Use short words. Mean what you say and say what you mean. And I realize I'm now getting a little redundant. Another thing that's important is to know your audience. Who are you speaking to? Are you speaking to the injured worker? Are you speaking to the insurer? Are you talking to the lawyers? Sometimes it's a mix of all of those. Are you talking to the judge? Are you speaking as an expert? Are you giving bases for your opinions? Know your audience. Know your limits. It's especially true for younger QRCs. You come in all idealistic and you're going to save the people. It's like the young idealistic lawyer that burns out quickly. Know your limits. It's really important to understand your role in the system. Self-cares. There was an ABA study, American Bar Association study, about 3 years ago that studied really chemical issues, depression, alcoholism in the lawyer world, and cranked out about 100-page report. And you can summarize it this way. It basically says to be a happy lawyer, you need to be a healthy lawyer. To be an effective lawyer, you need to be a healthy lawyer. To be an effective QRC, you need to be a healthy QRC. You have to take time to tend to yourself, to do those activities that restore and refresh your soul. I already told you I'm an inveterate runner. I get it. Not everybody likes to run. That said, there are hundreds of other things that you can do that will recreate you and restore you. And it's important to have that. Winston Churchill wrote a wonderful book that was published a long time ago called Painting as a Pastime. And in it, he talked about the mental stress and strain of the modern world. And the dude would know. I mean, he kept the world safe for democracy during World War II, right? It was Great Britain against the world for a long time. They were all by themselves. So the dude knows something about stress and strain. But in his book, he talks about the exhaustion from mental overexertion, and that a change is required, that a change is as good as a rest. And so to have activities that you do that have nothing to do with your job, hobbies. He says every person ought to have at least 3 of them. So find those and pursue them. And then, the last procedural or process type recommendation that I've got for you is to protect yourself. And what do I mean by that? This kind of alludes back to or references back to the trust your gut rule. What I mean by this is, if you've dealt with a law firm before and they're going to settle the case out and leave you high and dry with your bill unpaid, be aware of that. How's it go? Fool me once, shame on you. Fool me twice, shame on me. If an injured worker is not respecting boundaries, you need to do something about that. So, you protect yourself professionally, you protect yourself pecuniarily. I don't know if that's even a word. It's important to do that because not all people are nice. We know that all lawyers aren't nice. Not all clients are nice. And people's recollections change later on down the road. So protecting yourself isn't just doing the work, but lots of times it's documenting that you did the work. So now, if you put these things that I've just shared into practice, you're going to elevate your service. Now, you're not going to eliminate the cranky clients. You're not going to eliminate the abusive attorneys. You're not going to eliminate intrusive insurers. And to some extent, we just have to deal with it. I mean, we work in a difficult area where people are under duress, physical duress, financial duress. Claim reps are overworked. Lawyers are bossy and cranky and selfish. It's a hard place to be. You're stuck in the middle. But you serve an essential function, one that's defined by statute, one that isn't going away anytime soon. I know I don't have a crystal ball, but it's, we have vocational rehabilitation in the statute, and we have a long-standing tradition of it. So it would take a significant change of the legislature. And again, I don't have a crystal ball, but even though things might be slowing down right now, I don't think that voc rehab is a dead industry. I don't think it's a dying industry. Could be wrong, but from my perspective, it's an essential function. And I settled a case recently where my client said, and I told him, hey, you're all done with the QRC. My client was crestfallen. Oh no, QRC's been so helpful. I'm really going to miss that QRC. It was really helpful at doctor visits. I just didn't understand things. QRC helped me explain. QRC did a good job. Another refrain I've heard about a particular QRC, who I suspect is watching. This QRC has been referred to as an angel by 3 different clients of mine over the years, and none of them knew that the other person had made that reference. So that's pretty remarkable. I don't know too many people who get accused of being an angel, let alone once, twice, 3 times. And, helping an injured worker navigate the system through medical management and voc rehab, avoiding good enough rehab and seeking to get them back to suitable gainful employment, that's a worthwhile endeavor. And there's value in what you do, and you make an impact. So I will finish my afternoon drawl by saying, keep up the good work. I appreciate you. Thank you very much.
Thank you so much, David. That was a very informative talk. I appreciate that, and your flexibility in helping us out today, starting a little bit early. I don't see any questions for you in the chat box. So I'll give people just a minute there to enter any questions they might have for you. While people are doing that, I'll just let everyone know again that due to technical issues with Mike and Chris's connections, we won't be able to have the usual Q&A section right now that was planned. But you can send any unanswered questions that maybe aren't for David but are for others to Mike Hill at mike.hill@state.mn.us. And we will be trying to re-record the end of Mike's presentation, and we'll have that online on the 28th with the rest of the presentation, so you can view the entire thing then. I still don't see any questions for you, David. Did you have any closing remarks you wanted to leave us with, or? Oh, wait, a question just came in. It says, it seems the files are being settled for job placement much more often now than in the past. Why?
That's a great question. And that has been a trend that we've seen probably the last 10 years. It is because insurers are pushing to settle cases early. And frankly, there are lots of lawyers who settle cases quickly. It's easier if you do minimal workup and you settle the case quickly. You might settle it for less than it's worth as an attorney. But if you don't have a whole lot of time in it, you're doing well when you look at the bottom line. I have a phrase for that. I call it pump 'em and dump 'em. It's a law firm I would avoid. And I'm not going to get self-righteous because no one needs a self-righteous plaintiff lawyer. Here we go. Back to this. But that said, John, that's why things are settling out so quickly is there's a push. I mean, every time I file a claim petition, I get an email from defense counsel saying, hey, you want to set up a mediation to settle the case? And I'm like, my person has surgery recommended, and we don't know where they're going to end up. So there is a push, a shove to get them closed. So
there are a couple more questions. I don't know. Can you see the chat box? Can you see the questions coming in?
I can.
I'll let you go through them then.
So one says, if you have a DPL but found the injured worker to be a QE, and the insurer will not officially deny treatment, so the injured worker can use personal insurance, what do I suggest? So the answer to that one, if I understand the question, is this. If work comp has denied causation, the law in the state of Minnesota says that an insurer shall pay for treatment. The health insurer shall pay. It's 176191 sub 3. So typically what you have to do is get work comp to issue a denial letter, and then the injured worker can take that to their health insurance and say, hey. And the injured worker should be truthful when health insurance says, well, is this a work injury? Yes. Well, why are you asking us to pay for it? Because work comp is denied it. Here's the denial letter. And then that injured worker keeps track of their out-of-pocket expenses and co-pays, but that way they can get the treatment and not rot on the vine while the underlying causation issue is litigated, because part of the claim then becomes to get the health insurer reimbursed by work comp and also to get the injured worker reimbursed for out-of-pocket expenses that were incurred. There's a question from Steve Aldrich that says, have you seen a decrease in retraining plans? It's unbelievable. I can't say a bad word, so I won't. The word dearth doesn't even get there. Okay. I mean, cases settle so much more quickly than they used to. And not everybody is retrainable. We all know that. But there are a whole bunch of QRCs. This goes back to those two hats, medical management and voc rehab. Number of QRCs that either won't retrain or don't retrain because they don't know how. So not only is there an unwillingness to go that route, but there's a insufficiency technically. Technically, they're not skilled enough to know how to do that. Plus, you become a pariah. I mean, the insurers are furious with you and, how could you do that? But from a lawyer standpoint, a retraining claim is hard to prove. Why? Because you basically got to prove 5 elements. All right, there's 4, but you got to also prove it's physically appropriate. And you fail on any one of those and you're done. You lose. It's not substantial compliance. You lose. So they're hard from a petitioner perspective to prove up. And another question asks I asked a defense lawyer why they are more anti-QRC now. There are some lawyers out there that just vitriol. I use a good V word for you, vitriol. When you speak about QRCs, all you catch is vitriol. And I don't understand it. I call it drinking the Kool-Aid. I really do. And I've had discussions with some of these anti-QRC attorneys, and I'll be like, no, you are wrong. A good QRC is worth their waiting. Oh, I know, they just ran up the bill. But no, they don't. No, they don't. A good QRC actually is, going back to the very preamble of the work comp statute, is an essential component of providing quick, speedy, and efficient benefits to the injured worker. That's the goal of the work comp system, and QRCs help effectuate that goal. So, sorry, you're getting my ire up. I'm getting all fired up. I should chill out. But yeah, there is some animus out there, and I'm sorry about that. And there's a strain of infection that seems to be worse in some places than others. Kayleen asks a wonderful question. Would it be socially responsible to include basic job-seeking skills in settlement? It would, Kayleen, but I'm running into this all the time where clients just want more money. I mean, they start out saying, I'm not here because of the money. It's not about the money to me. Sure, it's always about the money. If nothing else, that's about all I can get somebody besides medical and voc services. I can get them money. So pretend we mediate a case, and this always happens all the time. We've been mediating the case for 3 hours. We're not going to close medical. We're not going to close medical. We're not going to close. They're up to $75,000. The mediator comes in. Okay, I've got door number 1 and door number 2. Door number 1 is $65,000 with medical left open, but they're going to maintain their denial. They're going to fight you on medical. Okay. or 90 grand, close meds. And I might say to my client, don't close meds. They're like, Dave, are you kidding me? I mean, they're fighting me anyway. Why wouldn't I take that? So, Kayleen, I think the same analysis is going to apply to basic job seeking skills and settlements. I mean, yes, it's a great idea for some, but most clients aren't going to want that. They're just going to want to liquidate things. Next question. Cases seem to be settling as soon as there is a sense of vocational complexity. This is, in essence, administrating vocational out of vocational rehab. This seems to leave many clients with disability, no skills, and out of work. Not necessarily a good outcome for the client. I agree. This goes back to this quick and easy settlement. There has been a movement where, first off, we didn't used to close out meds in the old days. We just didn't. Okay. Judges wouldn't approve settlements. And all of a sudden, auto infected work comp. And now it's pretty common to close medical. Not always, but often. And so you've got not only, the four, medical, QRC, wage loss, permanency, you're shutting them all down. That was a threatening fist. I'm sorry. But you're also shutting them down sooner in the system. And, you're taking people, someone, Johnny Lunchbucket, who's held the same blue collar job for 25 years, has a bad injury and the lawyer settles him out quickly. And Johnny Lunchbucket, with a good QRC, isn't perm total. Without a good QRC, might very well be perm total. I think I hit all the questions.
Perfect. Yeah, I don't see any other questions for you. Again, everyone, if you have any other questions that weren't answered, you can send those to mike.hill@state.mn.us.